Good morning, Mr. McLean. Sir, you're charged with interference with the duties of a public servant. You're facing
This hearing takes a surprising turn almost immediately. The defendant is charged with interfering with public duties, a misdemeanor carrying up to 6 months in jail. But as the details come out, the judge starts questioning whether there's even a crime here at all. The state's claim he was speeding, changed lanes unsafely, didn't have his driver's license, and stepped out of his car after being told to stay inside. The defense, well, they don't even have to say much, because the judge is already pressing the prosecutor on the most important point. What exactly did he do wrong?
You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Yes, sir. An officer initiated a traffic stop in Harris County, Texas, after observing the defendant exceed a speed limit of 45 miles per hour and make unsafe lane changes. The defendant did not have his driver's license, but told the officer his name and date of birth. While the officer was running the defendant's name, he observed the defendant exit his vehicle, and the officer told the defendant to get back inside the vehicle. And the defendant responded, "Do I have to?" The officer exited the vehicle and attempted to detain the defendant. The defendant tensed up and locked his arms.
Everything is conclusory. And what has he done wrong? What?
It was the initial lane changes, unsafe lane changes, and the exceeding the speed limit that prompted the stop. And then at that point, he was just...
Stop. How exceeding speed limit? How fast was he going? I mean...
This is where the judge starts dismantling the state's narrative. The prosecution says the defendant was going 54 miles per hour in a 45, but the judge points out that if it was on the 610 freeway, that's practically normal. The so-called interference, stepping out of the car and asking, "Do I have to?" before being told to get back in, the judge seems unimpressed. He's clearly signaling that minor non-compliance doesn't automatically equal obstruction, and the state is struggling to justify the arrest.
I spoke to the officer this morning who told me that he was pacing the defendant at 54 miles per hour.
Okay, in a what?
I'm sorry?
In a what? I mean, if it's on 610, he's fine, right? And then he's interference duties. What is he interfering with? What did he do wrong?
I think it was after the stop was initiated, the officer was running the plates. The defendant stepped out of his vehicle. The officer told him to get back in the vehicle. The defendant said, "Do I have to?" The officer told me that.
And that's the basis of arrest?
See how it was, but you're on.
Don't. Are you losing?
Oh, sorry.
Okay.
And Your Honor, furthermore, as he was attempting to detain him, he locked his arms and tensed up.
Here's the turning point. The judge bluntly says, "I find no probable cause." He explains that simply stepping out of the car doesn't interfere with an officer's duties, not without more. His tone shifts from legal analysis to personal advice. Life is hard enough. Be careful out there. Be nice, and things will go well. It's rare to see a case collapse this quickly, and even rarer for a judge to give this kind of almost fatherly lecture in open court.
Tensed up, so as he was attempting to detain him, following that incident of him telling him to get back to the vehicle. And it was that...
That's the basis for arrest.
It was just a temporary detention. He was just attempting to detain him while he was trying to
What's he
investigate.
doing wrong?
Yeah.
What's he doing wrong?
65. Yeah.
No, I don't think so. You find no probable cause. No, it's just, he gets out of the car and then it just the virtue of fact him getting out in the car is interfering with the duties. Really? No. Just, when you get into, just be careful out there, man. Life is hard as it is. When you get into, you gotta be careful, man. People always out to get you. Be nice, it's not hard.
In the end, the state still tries to argue that the defendant's actions obstructed their investigation, but the judge isn't buying it. With no probable cause on the record, the charge effectively dies right there. This short hearing is a masterclass in judicial pushback, reminding everyone that not every arrest holds up under scrutiny. If you found this breakdown as interesting as the judge's rapid-fire questioning, hit like, share your thoughts in the comments, and don't forget to subscribe for more real courtroom moments that don't go as the prosecution planned.
It's not hard. Things will go well. Look, I got it. I'm with you, okay? Just hang tight with me for a second, okay? All right. Okay, I have so many questions. No, it's gonna go back. Stop it. Are you losing?
Yes, sir, that's all we got.
Okay, ma'am, you are charged with interference with the duties of a public servant. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
The position of the state judge is that it did obstruct their investigation. I mean, it's not in this, there's multiple senses of obstruction in our opinion. It's not.
Are you losing right now? Okay.